The Hindu Succession Amendment Act of 2005 granted daughters the same rights and obligations as sons in a Mitakshara coparcenary. 1. Coparcenary membership. Daughters became coparceners by birth, with the same rights as sons. 2. Property rights. Daughters have the same rights to coparcenary property as sons. 3. Liabilities. Daughters have the same liabilities for coparcenary property as sons. 4. Kartas. Daughters can act as kartas, unlike before when they were not part of the coparcenary. And 5. Equality. The amendment removed the distinction between married and unmarried daughters. The amendment came into effect on September 9, 2005. It was intended to remove discrimination between sons and daughters, and to give them equal rights. The amendment changed Section 6 of the Hindu Succession Act of 1956. The amendment's provisions are prospective, not retrospective. Before the Hindu Succession Amendment Act 2005, under the Mitakshara school of Hindu law, when a male coparcener died with an undivided interest in a joint family property, his share would devolve upon the surviving coparceners of the family through the principle of devolution by survivorship, meaning his interest would automatically pass on to the remaining members of the coparcenary, essentially excluding daughters from inheriting directly as they were not considered coparceners. This significantly disadvantaged female heirs in accessing ancestral property. Key points about the pre-amendment law. 1. Rule of survivorship. The primary rule governing the devolution of a coparcener's interest was survivorship, where the surviving members of the joint family would inherit the deceased's share automatically. 2. Exclusion of daughters. Under the old law, daughters were not considered coparceners and therefore had no automatic right to inherit a share in the coparcenary property unless specific provisions under the Hindu Succession Act applied in exceptional circumstances. 3. Section 6 of the Hindu Succession Act. This section codified the principle of devolution by survivorship for male coparceners, with limited exceptions for female heirs in certain situations. And 4. Impact on female heirs. Due to the rule of survivorship, daughters often had to rely on claiming maintenance or other legal remedies to access a share in the ancestral property, which could be a complex and lengthy process. How the 2005 amendment changed the law. Inclusion of daughters as coparceners. The most significant change was granting daughters the status of coparceners, meaning they now have an equal right to inherit a share in the coparcenary property alongside their brothers. Equality in inheritance. The amendment effectively removed the gender discrimination in the devolution of coparcenary property, allowing daughters to inherit directly through the rule of survivorship. The Hindu Succession Amendment Act of 2005 changed the law relating to devolution of undivided interest in a Mitakshara coparcenary in several ways, including 1. Equal rights for daughters. Daughters were given the same rights and responsibilities as sons in a Hindu undivided family, HUF. Daughters became coparceners in the HUF from birth, and were granted the same rights to the joint family property as sons. 2. No distinction between married and unmarried daughters. The Parliament removed the distinction between married and unmarried daughters. 3. Removal of bias in Section 6. The amendment removed a bias in Section 6 that considered the male line of descent up to 2 degrees, but the female line only up to 1 degree. 4. Removal of exclusion of female heirs. The amendment removed Section 23, which excluded female heirs from claiming a partition of the dwelling house. And 5. Allowed daughters to act as kartas. Daughters were now allowed to act as kartas, which they were previously barred from doing. The amendment came into force on September 9, 2005.